Michigan, and he knows better than most, much better than I, about these types of things. And let's talk about what we've seen so far. Let's start with, Jamie, the issues with the jury. Yesterday, it starts off with a juror basically alerting the judge, hey, I heard this juror talking about court TV coverage. She was talking about it with the parents. Judge says, all right, well, let's go look through this thing. Wow. She starts it, and a can of worms comes out. And then another juror says, oh, yeah, this guy was talking about the fact that the witness didn't need glasses, which he was reading, yet she's testified that she needed reading glasses. Another one says, well, men like to fight. All part of this trial. Did the judge make the right decision to, after inquiring, which with each and every one of the jurors, decided to move forward with this panel?
Yeah, Ted, I think she did. We've seen this before in media cases where, despite the initial instructions from the judge, individuals go out and do something to the opposite. There will be a curative instruction, and as you talked about in your opening, there certainly will be an admonishment as the jury comes back into the courtroom. But I believe at the end of the day, she did make the right decision. This is certainly not unusual to see jurors stray off the path to some degree. And as long as it isn't anything that extremely prejudices the defendant, I think the court made the right decision. Now, with that said, Ted, what this clearly does is open up the avenue of appeal for the defendant in the event that he's convicted. So that's always, from my point of view, that's always a consideration that the people have to take into consideration while your trial's going forward and you want to stand up for the court and so on. At the end of the day, have you opened yourself up for an appeal? So I think that it cuts both ways a little bit, but I do think the court made the right decision and based on the facts as they've been presented so far.
This morning, the lawyers are to report to court around 9:15. They still haven't come into the courtroom. When they do, we'll obviously go into the courtroom. Then it is the closing arguments from both sides, expected after jury instructions are given this morning. If you're the defense, this is a case where the state has one star witness who gave her account of what happened but did break down on the stand at the end of her testimony because she was overwhelmed with the cross-examination. Then you have the defense who brought up two witnesses of their own who were there when this happened.
Correct.
What's your theme if you're the defense going in addressing this jury? Do you attack the credibility of that star witness?
So the theme is reasonable doubt, without a question. This is an easy call to make. You have individuals where there were at least three witnesses, arguably, and people are pointing fingers at each other, at least pointing fingers at different sides of the story. Miss Boyette, I believe is her name. She was impeached to some degree on the stand. And at the end of the day, presuming the defense has done a good job of educating the jury from voir dire through closing arguments about the concept of reasonable doubt, at the end of the day, you don't convict a man when you have people pointing fingers at each other. Now, there's a lot of other evidence in this trial, but based on the witness testimony alone, when it comes to closing arguments, your approach is reasonable doubt is something that everybody's entitled to, and have they overcome that burden in this particular case? And I think the argument is easy based on the eyewitness testimony that they have not. Now, again, there's other evidence that I expect is going to come into closing arguments. The fact that he was on the victim's property and went there, without permission, and some of these other issues could sway the jury to find, some level of intent, or at least in recklessness enough that intent can be derived. But the defense has one job today, and that job is to explain to the jury the concept of reasonable doubt and explain to them how high that burden is. And that if we have 50-50, I used to use, when I was doing murder trials, I used to use what I call the scales of justice theory. And I would tell the jury, when you go back in the room, put all the evidence on a scale and put all the defense evidence on a scale. And if the prosecution's evidence doesn't slam down to the table in a convincing way, that's reasonable doubt. In other words, if we're doing this if we're not sure, if we're so, that is certainly not proof beyond a reasonable doubt. And I think that's the defense job today.
Yeah, that's a great visual there with the scale, especially with the scales of justice. Let's talk
Sure.
about the charges here. You brought him up with this burglary issue, and he's facing 3 charges: first-degree felony murder, burglary of a dwelling with assault, and the burglary is key here because that makes it a felony murder. If you don't think that he's guilty of burglary, then the first-degree felony murder goes away. Let's bring up the definition of burglary, because people think burglary, oh, that's like the Hamburglar. You got the mask and you go in and you steal stuff. That's not
Sure.
all of it. Here's exactly what it is in the state of Florida. It means entering a dwelling, structure, or a conveyance with the intent to commit an offense. That's key. With the intent to commit an offense. You don't have to commit an offense with the intent. As soon as you cross the line, you're guilty of burglary, unless the premises are open at the time to the public or the defendant is licensed or invited to enter. A couple things here. Was he invited to enter if you believe that the gate was unlocked by the victim and the victim struck this defendant first? Is that a strange invitation onto his property?
Ted, I think that's probably a bridge too far. The fact that there was a gate and it was open, doesn't, in my opinion, does not negate the issue of whether or not he was invited. In fact, it's, in my opinion, legally that if there was no gate, no fence, he still could be subjected to the burglary statute under these circumstances. I think, Ted, that the real issue, and you touched on this, is intent. Did he intend on going to that property for the purposes of committing an offense? And I think that is really where the defense needs to put their laurels. Because, while arguably he was inflamed and had some issues, whether or not he intended on actually committing an assault, I think is completely speculative at this point in time. And that's where I think the burglary charge fails on its face. And to your point, and with that goes the first-degree murder charge, or at least the felony murder charge. Whether or not they get lesser included and they're allowed to make those arguments to the jury, that is yet to be determined. But if, in fact, the jury does not believe in the burglary charge and there is no instruction for lesser included, the prosecution has a great risk on their hands.
The defendant decided not to take the stand. He was questioned about that in court. Let's take a listen.
You understand that you have the ultimate decision power to decide whether or not you are going to choose to testify in this case.
Yes, ma'am.
That means your attorneys are here to give you advice, tell you the pros and cons of testifying, and practice with you if need be. But the only one who gets to decide that is you. Do you understand that?
Yes, ma'am, I do.
If you want to testify, they cannot tell you you cannot. Do you understand that?
Yes, ma'am.
And if you do not want to testify, they cannot force you to testify. Do you understand that?
Yes, ma'am, I do.
Have you had enough time to form an opinion about whether or not you wanted to testify?
Yes, ma'am.
And what is that opinion?
I'm not going to testify.
Good decision there. What's your take?
It's a tough call. It's, common opinion is that, defendants probably should not take the stand in their own defense. His statements have been pretty well recorded in this matter, and the only thing that could happen on the stand would be for him to be impeached. So I don't disagree necessarily with the defense strategy. With that said, Ted, juries want to hear from the defendants, right? I mean, this is just, anybody that's tried cases, you talk to a jury after the fact, you can educate them all you want about the right of a defendant not having to testify, and it can't be held against them. But they say over and over again that they wanted to hear from the defendant. In this case, as harsh as this sounds, the witness is dead, and the only real risk would be some level of impeachment, which, based on the little bit that we've seen from Mr. Robinson through his statements to the police, he seems to be an articulate man, and that risk probably was worth taking, I suppose, at the end of the day. I mean, we'll see how things work out, but I think that to have this man go up and tell the jury what happened from his own words probably has a lot of value, and maybe it was a big mistake to not, or maybe could have been a big mistake not to have employed.
Yeah, I mean, his words were played, his account was played in an audio version, but there was no transcript to go along with it. Audio is always hard to, pick up the nuances. It's different, isn't it, than having the guy that's accused sitting a few feet away recounting his story. All right, we're going to step aside, take a break. They still haven't gotten up and running yet in the courtroom. We can see the seal. Our cameras are on the seal. And as soon as the judge takes the bench, we'll take you into the courtroom. You're watching Court TV. Stay with us. We'll be right back.